lawyers then appealed the sentence. Subsequently, the latest were reporting from the court indicating that the Court of Appeal has dismissed the sentence in the first place. It shouldn't have happened. And so it also means that she has been acquitted. And the charges preferred against her are the following: stealing and conspiracy to steal, causing financial loss to the state, money laundering, and then causing loss to public property, improper payment of public funds, unauthorized commitment resulting in a financial obligation for government, and then contravention of the Public Procurement Act, meaning failing to adhere to procurement laws in purchasing goods and services, as she was the chief executive for Maslock. Now, speaks volume about what the charges in themselves are. We'll be speaking to a number of our key stakeholders, but particularly our leading legal practitioners. And Beatrice, it speaks a lot about what has transpired over the period.
Indeed. And I remember when she eventually came to the country, there was a conversation about a win, as it were, for holding people accountable for their actions and inactions, because the challenge was that when she was tried, of course, when she traveled out of the country on medical ground, she had not come back to serve her term, as it were. And so if she had arrived in Ghana on the 9th of June, the expectation was that she would go in and serve her term. And so with the appeals court now coming in to acquit and discharge her, these same old questions, I believe, in the coming hours and days will be posed again. And really, what is the way forward? I mean, after the appeals court, you have the opportunity of going to the Supreme Court. Is this something that the state is going to challenge at the Supreme Court just to prove a case that, well, it has evidence, but the court is saying that there doesn't seem to have been much in terms of the reasons that led to her sentencing? And just to bring you a quote from what the court said, that indeed the former Maslow CEO, Sedina Tamakloe, should not have been sentenced in the first place, as the prosecution could not prove the charges leveled against her. So does it mean that when she was jailed by the High Court, then when the trial started and eventually ended in that sentencing in absentia, there were no substantive evidences or proofs to back, the prosecution? And I think that's something that in the coming hours and days, like I said, we'll be seeing. Well,
subsequently we'll go to the court. We'll get to know what the content of that judgment is, but particularly for our reporters who were on ground, not only of the presence of the courts, but importantly in the chamber or in the court itself when the judgment was being given. What are the contraindications and then the concerns that will be raised subsequently or not by key commentators and then practitioners when it comes to the law and then the subject matter. We'll speak to Lord Idwansari. He's our lead court reporter, was in court when the judgment was being read, and subsequently reasons adduced or perhaps cited also by the court for this dismissal. Now, it also means that if there has to be a case, of course, it has to be brought by the Attorney General, who is the chief prosecutor for government, and that was undertaken in the Kufuor administration. And subsequently, they went through all the processes of the prosecution. They were hearing evidence adduced, and subsequently, the conclusion made in that judgment, and in absentia, because she was not around, but her defense again in court at the time, she then was sentenced to 10 years imprisonment. And this is where we are currently. And following orders from the Attorney General, an application was made to the government of the United States of America, to the Department of Homeland, as well as the State Department, for her to be repatriated back to Ghana and then come to serve her prison sentence. She began that in earnest, and her lawyers then appealed that sentence. And this is where we are currently. But Beatrice, it speaks to a big subject matter in the public domain, while we're looking at the side of the law about what could be the ramifications for this or the repercussions on public opinion, and then subsequently what the concerns could also be experience as well.
Indeed, when we've been having conversations in recent times of whether or not we are applying the rule of law fairly with or without political interest. But I want to remind you again, if you're just hearing of the case for the first time or you've lost track of really what led to the sentencing in the first place, Sedina Tamakloe was accused of misapplying funds, stealing, and among all the charges that Roland read to you just some minutes ago. But again, in terms of the details, she was accused of embezzling some 3.19 million Ghana cedis during her tenure as Maslock CEO, and also causing deliberate financial loss of some 1.97 million Ghana cedis to the state. Again, she was accused of making unauthorized commitments resulting in financial obligations totaling about 61.74 million Ghana cedis for the government. I did say earlier that in total sum, you were talking about 90 million Ghana cedis. Again, if you want to break it down, approximately 500,000 Ghana cedis of Maslock funds, per the allegation, they claimed was sent for personal use after it was returned from a private microfinance company, Obatampa Microfinance Company Limited. The second allegation was that she also withdrew over 1.8 million Ghana cedis in tranches after Maslock board approved 1.7+ million of Maslock funds for a countrywide sensitization. And then out of the 1.8+ million Ghana cedis for the sensitization program, the allegation was that only 1,300 was spent on refreshment for some beneficiaries in the Volta, Greater Accra, and Bono Ahafu regions, with no program taking place in other regions, and around 579,000+ Ghana cedis out of the sum of over 1.4 million Ghana cedis meant for victims of the Kantamanto market fire disaster in 2013 was also part of the charges against her. And this very allegation was something that got a lot of people talking, because you're talking about victims of a fire and money has been made available for them, and eventually they didn't end up getting the money. So as a result of that, of course, like I did say, in April 2024, after she left the country on medical ground, she was then sentenced to 10 years in prison in absentia. And again, I was telling you about how on the 9th of June she arrived, and the expectation was that we see the, as it were, the implementation of the court's decision, and this is where we are.
Well, we have to go to the courts. We have Bernice Abu Lansa Beidu on ground to give us the latest. Bernice, what can you tell us?
Hi, Roland and Beatrice. It's quite a morning here at the Law Court Complex, and the news is still trickling down. So you find people gathered, trying to discuss what they've just heard. Hopefully, shortly, we will have state prosecutors and lawyers of Sedina Tamakloe file out so that we can get a bit more on their reactions after the court's decision. But we know how far this case has traveled, and you've been reiterating all the events leading up to this point, and the investigation starting as far back as 2017, and proceedings beginning in 2019, 2 years after that. We know that she did require permission from the court, which was granted for her to seek some medical treatment outside the country, after which she didn't return. We know that after the NPP lost power and the NDC came back, she did return to the country. There were concerns about the exact location of the convicted former Maslock CEO, and which got a lot of people talking. Even in Parliament, we were told much later that she was sent to the Nsawam prison. This morning, the court has made a decision on the matter, and my colleague Lord Iduasari, who is in court or was inside the court following the proceedings, will be joining us with more details on that. And so we will be sharing more information with you. Lord will be telling us more on that much shortly. And also, like I mentioned, we we will be getting reactions, especially from her lawyers who have been fighting this, who believe that she did have a case. And so we will be getting you all the details that you need to hear much shortly.
Well, subsequently, where the courts will give you the latest updates, and Lord Edouard Sare was in court when the Court of Appeal was giving that judgment as well. And so far, every indication is that, well, she now can go home, barring any other actions that could be taken in court. But importantly, just to give you the grounds on which, and particularly also the grounds on which the appeal was based from her defense lawyers, will give you up to speed what the latest grounds have been, what the arguments were made from court, and then what also you can know. Based on the subsequent introduction, they went through the salient facts of the case, and then did a bit of recollection that according to the prosecution, investigations did show that in June 2014, Maslock invested an amount of 150,000 in Obatampa Microfinance Company Limited, which was a licensed Tier 2 microfinance company at the time located in Ejura in the Ashanti region. That after the investment of the said amount, the appellant offered to invest an amount of 500,000 Obatampa based on the offer from Maslock, and so they had the money going to the recipient at the time. Now, the case of the prosecution was that, well, we had the appellant, who in this case will be Madam Sedina Matiunu, who said to have allegedly dishonestly appropriated the said amount, for which she was then prosecuted based on the conclusion of the court. And then following that prosecution, we are here today, her lawyers are appealing. And it also means that according to what the content of that judgment, based on what we're reporting, the court said this shouldn't have transpired or happened at all. It also means that that decision has been quashed, and then she has been acquitted of such charges, and then subsequently the terms of imprisonment do not hold, and so she is, in plain English, a free woman. Plain English again, supposed to go. The case of the prosecution, also, you take a recollection of the case, also speaks to what might have transpired when she was chief executive of Maslock, how she also supervised as the lead manager for the state entity, and then subsequently how she supervised the conduct of her assigns and officers in that office, and then the concerns that had been raised on issues even of PPA approvals, and then contraventions of the PPA Act pursuant to the various sections of the PPA Act as they are. We'll give you the latest, because based on the particulars of offense, and then the statement of offense, more importantly, and the count, stealing contrary to section 1241 of the Criminal Offences Act, that will be Act 29, and then others that we've also brought you. You'll get to know. The main concerns are the charge which formed the basis of the conviction was said to be defective, and then none of the witnesses called helped to prove the said charges based on the grounds of appeal from her lawyers, and then the prosecution, according to them, failed to prove that she appropriated any money. And those were the main grounds of appeal based on what we're teasing out from the writ in itself, and subsequently the conclusion that has been drawn by the Court of Appeal as per what the writ was filed, and subsequently what the issues were raised on grounds of appeal. And it also means that this has been overturned, and of course going to get a lot of traction on social media as well. If you're watching us particularly on YouTube and Facebook, it also means that you will certainly have an opinion about this. What do you make of this as we have it trickling in? And then also, what's your own opinion on this? So we have a couple of you already with us on Facebook, and subsequently I have Beatrice read a couple of them as well. Of course, editorially we have to sift through as we always do, and if Beatrice is ready, we'll also go through. But a couple of you saying that this is part of one of the political cases, and then of course chastising the Attorney General, and then of course the government of the NDC and President John Dramani Mahama, and so I have this one from Capo. Okay, it will be Capo K Kufo. It belongs for us to